Good morning, members. It's the appointed time, and we have a quorum. I call the meeting to order. Let's invite the government officials to enter. Regarding the list of follow-up actions arising from the meeting on the 15th of October, the administration have submitted a response. I will ask the administration to brief members on their response. If you have any questions regarding their response, you can press the button. Good morning. Welcome. Mr. Howard Yam from the Secretary Bureau will perhaps brief us on the response that you submitted. Thank you. I will ask Ms. Chung to brief members on the paper that we submit, and then we will take questions. Thank you, Chairman. Good morning. We have submitted its response to the issues raised at the meeting on the 15th of October. We have detailed the offenses that are of similar nature under the bill and the Fire Safety Buildings Ordinance, including Section 18, persons obstructing persons exercising or performing functions under the ordinance, as well as 19L, that targets defaulted works. That includes or concerns the offense of obstructing specified persons in carrying out defaulted works. These offenses are similar in nature. It relates to obstruction of the performance of functions under the ordinance. When we set the penalty level, we have considered the similar nature of these two offenses. So in terms of wordings, the elements of offense and the penalty level, we have aligned them to make them consistent. On the second item to follow up, the members ask us to elaborate on the persons covered under the proposed new division Part 2 of Part 3 of the ordinance. Well, specified persons are included in the division that cover authorized officer and auxiliary persons. Authorized persons include direction of fire safety and director of buildings, as well as police officers authorized. As for auxiliary officer, it refers to the engineering consultant and the contractors engaged by the enforcement agencies. So auxiliary persons refer to these engineering consultant and contractors engaged. As for the other persons referred to under Section 19F, it refers to the person who may exercise powers specified with the assistance of any other person, whereas assistance specified persons considers necessary. They also refer to the engineering consultant and the subcontractor engaged by the contractor. As for the Chinese drafting of the Section 19M(1), we thank the members for their suggestions. We have improved the Chinese drafting, and we have taken on board members' views. Through the proposed amendments, we will make the provisions more easy to understand. We have also made relevant adjustments to the English version. The text is set out in Annex 2 to the paper. The meaning of the original provisions are retained after the amendment. Now, the next item relates to how the administration or enforcement agencies or authorities could recover the surcharge and the costs. The members ask us to explain clearly about how the enforcement authorities recover the costs and the surcharges. We have made a flow chart attached to the annex. As to how we apportion the cost, as mentioned, the defaulted works are conducted or carried out in the common parts. So the cost will be apportioned based on the shares of ownership outlined in the deed of mutual covenant. Even for buildings without DMC, they will keep a record of the share of ownership in the land registry or in other places. Under such circumstances, the EA will apportion the cost based on the share of ownership of buildings. However, even though there is no record of share of ownership, the EA will charge the relevant owners based on the floor area of their flat. The member also asked about how the administration or the EA should recover the cost or surcharge, and would it happen, or would it be the case that there will be sometimes when EA cannot recover the cost from the owners? We have made reference to the buildings ordinance, and we have considered all circumstances. It will not happen. Well, we will not. The EA will be able to recover the surcharge and cost in any case. The member also asked about the service of writs of summons. According to the experience of the buildings department, the DOJ will serve the writs of summons via registered mail. The administration will resort to all means to identify the last known address of the person. We will reach out to the RMVD and the Immigration Department in order to figure out the last known address of the person. If that person is a company, then the government will conduct a company search. If that person is a partnership, then the government will look up the business registration certificate in the business registry so that we can figure out the location of the place of business in order for us to adopt the most effective ways to serve the writs of summons. There were members who also asked about the Section 14B bracket 1. We have explained it in the document. Section 14B bracket 1 only applies when the order or direction is not complied with. It has to do with the mechanism on how the EA recover the cost. When the EA recover cost or surcharge, it only happens when defaulted works is involved. So it's not relevant to Section 14B bracket 1. There were also members who asked if partners who are not actively managing the partnership will be held liable if other partners commit an offense. However, under Section 22A bracket 3, if an offense under the ordinance is committed by a partner of a partnership and it is proved that the offense was committed with the consent or connivance of any other partner concerned in the management of the partnership. In other words, if the partner is not engaged in the partnership, then they will not be held liable. However, we will take into account all the evidence and the actual circumstances. We will also seek advice from the judiciary from the DOJ, as well as making reference to the prosecution code before we decide on whether prosecution should be initiated. Thank you. Ms. Doreen Kong, I have 2 questions. I thank the administration for their detailed response. I'd like to refer you to paragraph 11 of the paper. Mr. Andrew Lam mentioned many times or asked how the apportionment should be done when there is no DMC. In paragraph 11, you said that if the share of ownership is not set out in the DMC, then you will apportion the cost based on the size of the flat. Have you set such mechanism out in the bill? If not, how would the owners know about such arrangement? If this is not stated in the bill, then there could be disputes. I'd also like to talk about paragraph 18 regarding how we can recover the cost or surcharge. In paragraph 18, you are trying to refer us to section 19T UVW. So last night, I read the provisions once again. I have discovered a problem. Under 19T, if you refer to 1A, it is said that if defaulted works is done, A, then the person who need to pay the works or the cost or surcharges would be the person who is the owner of the building on the date on which the works are completed. However, in 19V, it is said that if a recovery certificate is to be issued, then the person who is the owner or person who appears from the land register to be the owner of the building would be the person who needs to pay the cost or surcharge. How come sometimes under 19T1A you said that the person who is the owner of the building on the date on which the works are completed should pay, but then when the recovery certificate is issued, then the person who appears on the land registry to be the owner would be the one to pay? This may be your prevailing practice, but I have actually made reference to section 33(6) under the Buildings Ordinance to see if similar arrangement has been set out in the relevant ordinance. However, there is no AB under section 33(6) of the Buildings Ordinance. It only said that the cost and surcharge would form a civil debt. However, under this bill, at different stages, different people should be responsible to pay the cost and surcharges. There could be confusion. Deputy Secretary. Thank you, Ms. Kong, for the question. Regarding the first question on the apportionment of the cost, the mechanism was not set out in the bill. The most direct way to apportion costs is to be based on the shares of ownership outlined in the DMC. We will only recover costs reasonably, as set out in paragraph 11. We make use of DMC to apportion the cost, and if there is no DMC, there could be records in the land registry or other support evidence. If those are not viable, then we will make use of the size of the flat to apportion the cost. regarding 19T and 19V and how they relate to each other. Well, for 19T, as Ms. Khan said, if there is an owner or a person who is the owner of the building on the date on which the works are completed, they would be responsible for repaying the debt due to the government. However, when we issue the recovery of certificate, a few things would happen. First, it could be the case that they are the same owner, so they will be responsible.
Well, the second scenario is we have a new owner, and owner B comes into place. Now, when owner B comes on the scene, and he is aware of this recovery certificate being present, then under 19B there is an obligation imposed upon him or her, but it doesn't mean to say that under Section 19T, the first owner would be exempted from the responsibility. Under 19T, like Ms. Kong said, this is a civil debt and this can be pursued. Just because of the presence of the next owner doesn't mean that the liability would be gone. In actual implementation, we would pursue the first owner on this. And under 19T, we would resort to other means under 19V to implement the remaining recovery work. And under 19T, if we're talking about the same owners, there will be no doubt about it. Can you elaborate a little more about the apportionment? Will you be informing the parties concerned they'll have to be paying the money? Chairman. Now for these defaulted works, there would be sufficient communication with the owners. We will establish relationship with them. If there are OCs, there would be close communication and support for them. We've covered this before. In terms of apportionment, they will understand our practice, and there would be the demand note received by them. Mr. Andrew Lam. Chairman, thank you. I've asked a couple of questions before. I'm grateful to the administration for the detailed response. Everything is clear except perhaps the recovery. You have given us the flow chart, and this is really clear, but there is an assumption. Now for these payment in arrears, this may not be a large amount. But you are assuming in the flowchart that it would be handled by the Small Claims Tribunal. That's below $75,000. That's in a smooth situation without a lot of interests incurred. The penalty would be a different thing. Now, if it is beyond $75,000, how are you going to deal with that? DS. Chairman. Now, whether we are going to go to the Small Claims Tribunal is not necessarily the case. For all the outstanding payment due to the government and all the outstanding demand note, the DOJ would pursue the civil debts or judgment debts. So there are many different means at our disposal. If it is beyond $75,000, we'll have to go to a different court. Mr. Lam. Now, with the DOJ, now when a case is referred to the DOJ, they received your documents. How long do you think they'll be sitting on the case before they will decide how to proceed? Any particular procedures there? DS? But the enforcement authorities will be communicating with the DOJ, and they would be concerned about the progress. As to the internal procedures of the DOJ, I don't have them here, and the EA will generally maintain communication with them. And in some cases, the EAs would have to identify more information, like addresses for the DOJ to issue notices to the owners. And the owners, upon receipt of the legal documents, will then follow up. We will monitor closely the progress. And we will have regard to the existing cases regarding the demand and recovery. BD, any experience you can share? Mr. Ng? Ms. Ng? Yes, Chairman. I mentioned this last time. We will be monitoring the cases. When they are referred to the DOJ, we would send a reminder and ask for the progress. We don't have the time frame regarding the actual implementation. But we will be maintaining communication with the DOJ and ask them about the state of play. If there are some points where they need the most updated information about the person involved, we would sometimes go up to the property and ask about the owners. We would certainly maintain communication with a view to recovering the debts. Mr. Lam. Chairman, I don't really want to impede the progress of this bill. I'll be writing to the DOJ about the progress, about the procedures myself. Mr. Kwok Wai Keung. Yes, Chairman, about the principle for apportioning the costs. I appreciate that the administration will be acting in accordance with the DMC. Failing that, you will be go by the size of the properties, the GFA. The DMC can be very complicated. There are also the undivided shares for the common facilities, but for certain facilities like lifts, the certain part of the area, like the ground floor, will be taken out of the equation. And you also have the apportionment according to the undivided shares. And DMC can be terribly complicated. In some cases, the estate management will have to debate among themselves how to apportion the money, and litigation might arise. So my question is, in the process of working out the apportionment, if there are legal proceedings arising out of that, do you have any contingency? Do you have any anticipation of this happening, and how are you going to deal with that if there are litigation costs? Would you be recovering the litigation costs from the owners themselves? And this is really dear to my heart. If you are going to do this, then chances are the owners would not really be prepared to go to the court because they will have to bear some of the costs. So they might not be prepared to go down this path. So I'd like to find out more about the administration. Yes. Ms. Doreen Kong also mentioned this. What is the overriding situation? Chairman 19U183. the cost and the surcharge. That an apportionment among the persons that the authorities consider appropriate. That there's Roman 4. If indeed there are some documents that are objective enough that would not be controversial, then we'll be acting in accordance with the DMC or these kind of documents. Mr. Kwok mentioned a moment ago, you may have the documents and still there might be controversies. And we would be acting in accordance with all the documentation and all the instruments, and we will be adopting reasonable means to resolve the issues. Like what we do when dealing with these defaulted works or the works under the Buildings Ordinance or the Fire Services Ordinance, we would emphasize communication. If we can do a good job in communication with the owners, then the chances of legal proceedings or litigation would be small. If legal proceedings were to take place, the administration would certainly respond to that. We may have an apportionment plan if people are contesting that and would like to go down the legal path. Then it would be ultimately up to the court to take the final decision. Right, the litigation costs and also the cost decision, and we have to the existing procedures. Mr. Kwok, Chairman, you have picked up on the point that I was going to make. Now, with the litigation costs, it would be up to the court to decide who to bear, of course, but now, there are two parties, the department and the owners. If indeed the court were to rule that the department will have to bear the litigation costs, so will the government comply with that, or will they be recovering the costs from the owners? DS. Now, if the court has handed down a ruling, the department certainly would respect this decision, that's for sure. Mr. Orin Kong, Chairman. Also, on the question of apportionment, the administration said a moment ago they would be sticking by the instruments, or failing that, they would be adopting reasonable means. That's an ideal situation, but in the real world, in the buildings, the DMCs before 1990s, the apportionment can be terribly complicated. I've handled a housing estate. I won't name it. There are so many units. Because of the sheer number of units, the apportionment basis is not sufficiently clear. So, Mr. Chairman, for FSCO, now this may apply to the older buildings, and at that time, the clarity regarding the DMCs is not really good enough because there is no regulation there back then. Now we are going for mediation these days. Would you consider the fact that you might wish to refer this to mediation? I'm not saying that you should write this into the law, but when you encounter these kind of complicated cases, would you be considered alternative means? Also, Chairman, now regarding the who should be held responsible to bear the costs, now the administration cited so many different scenarios. I do appreciate that. Now, when the work is in full swing, it may be owner A, but when it's completed, it may be owner B. In a housing estates, these kind of works can involve up to 1,000 units. So it would be very complicated for you to work out the apportionment. Now you are creating so many different scenarios. do you have the necessary manpower, and what mechanism do you adopt to apportion the costs? The Section 19T and 19V, you have created so many different scenarios. Now, for the bona fide buyers, the 19V7. Now, for the bona fide owner 7, if after the completion of the works, but before the registration of the certificate, now that's a very narrow, tight spot. Now, that's before the works are completed, the property changes hand. Would you regard that as a bona fide owner? That's a very narrow spot. And before and after the completion of the work, there may be new buyers. Do you have the manpower to differentiate these different scenarios?
Deputy Secretary, thank you. Regarding apportionment, well, because the process of defaulted work started before the actual renovations and maintenance. Defaulted works is nothing new to the buildings department. So in terms of actual operation and disputes, I will ask Ms. Ng, Assistant Director, to elaborate on the actual operation, and then I will talk about the bona fide purchaser issue. Ms. Ng, thank you. Let me talk about the actual operation of defaulted works. I understand that members are concerned about the apportionment of cost and if we can recover cost and surcharges. Well, we've been carrying out defaulted works for a number of years. We don't decide on the apportionment after the defaulted works is done. For some buildings, there is the wall belonged to an owner and the flats belong to other owners. We actually look at the deed of mutual covenant. And if it's too complicated, we will write to DOJ and ask them how the apportionment should be done. After the defaulted works is completed, then we will follow the advice from the DOJ on the apportionment. We understand that DMC can be very complicated, and when we come across such cases, we consult the DOJ in advance. Ms. Khan asked about also Section 19T. Under the Buildings Ordinance, we recover the cost from the owner who appears on the land registry on the date of completion of the defaulted works. The reason why we have 19V is because let me put it this way. When our colleagues issue demand note, we issue that to the owners on the land registry. As for apportionment, as mentioned, we look at the DMC, shares of ownership. Ms. Khan is worried about what happens when there are thousands of owners in a building and what happens when there is transfer of interest. Well, actually, in actual operation is not that complicated. We issue demand notes and we recover the cost. Even when there are thousands of owners in a building, not a lot of them would refuse to pay. When legal proceedings is involved, we will refer the case to the DOJ, and the DOJ would try to recover the cost from the person to whom the demand note is issued to. There could be individual owners who have passed away, such that the DOJ cannot recover the cost from that owner, A, for example. Then the DOJ may invoke Section 19V to recover the cost from the owner who appears on the land registry at that point in time. 19V is here to give the administration another option to recover the cost. All along, we have been recovering cost from the person to whom the demand notice issued to. The actual operation of the provisions are not that complicated in reality. The Deputy Secretary, as Ms. Ng has explained, 19T1, well, the owners under 19T1 is the person to whom we would recover the cost from under most circumstances. If Section 19V has to be invoked, then under subsection 7, we will recover the cost from the bona fide buyer. The administration will recover the costs from the person who has acquired and registered an interest in the building concerned as a bona fide purchaser. The buyer may declare themselves as a bona fide purchaser. If the court is satisfied, then the subsection 7A and B will be invoked. Next, Professor Priscilla Lang. Thank you. Chairman. Now we are coming to the end of scrutiny of the bill. The member just now talked about mediation. That's what I'd like to talk about as well. When we discussed mandatory sale or compulsory sale of buildings, we encourage mediation first. Even under the DOJ agreements, they also encourage mediation first, litigation later. Community mediation targets such issues. CAP 572 is very important because fire safety is involved. However, members of the public may not be aware of the availability of mediation service. Maybe we should set out in the law that owners should try to mediate first. The reason why we promote compulsory sale under the why we promote a mediation under the compulsory sale ordinance is because there have been a lot of disputes between the owners and the developers. Some owners spend their life savings to sue the developers because they're not willing to sell their flat. And the district councillors and the legislative councillors became the mediators. I appreciate the fire safety or fire services department because when it comes to Mongkok and Matawai, your colleagues were very patient. However, if there is a professional mediator, then we will see fewer litigations because very often district councillors would serve the role of a mediator. DOJ would not want to be involved in such minor cases. Mediators may not have a legal background, although that could be an advantage. I myself took mediation courses. Even for mediators without a legal background, they would be trained in emotional management. So I think that you should look into it together with the DOJ. DOJ is now promoting mediation as well, especially for these minority owners. They should be encouraged to make use of community mediation services. Deputy Secretary. Thank you, Chairman. Thank you, Professor Leung. We understand that mediation is very important, and we are aware of the availability of community mediation service. A lot of disputes arose because of unstable emotion of a lot of different parties. So we have a one-stop mediation service, and we also have a team of social workers. In our centers, we will try to provide various forms of support. Chairman, some departments put their principles in their guidelines. Maybe you can do the same. You could put in your internal guidelines or external guideline that you encourage mediation because it could be cheaper. Please consider. Thank you. Next, Ms. Carmen Khan. Thank you, Chairman. I'd like to follow up on Ms. Kong's question and the administration's reply. I thank the administration for their detailed response. Apart from 19T, V, and 14B, because under 14B, the responsibility of new owners to inform the EA of the transfer of interest is not set out under Buildings Ordinance. Can you give us the scenarios that we should take into account? Because under 19T, it is said that the owners on the date of completion should repay the costs and surcharges. EA will issue the relevant owners the demand note. That would be a civil debt. Under 19V, it is said that a legal charge can be charged to or charged against the property in the land registry so that the owners would be more incentivized to pay because they would not be able to sell their flat otherwise. For recovery certificates, it will only be issued when the owners are not willing to pay. So I think that you should give us certain scenarios. So how long after the owners refuse to pay the payment set out in the demand note will you issue the recovery certificate? Under 19V3, it is said that the owner who appears, or the person who appears to be the owner of the building, what if, well, there won't be any problem if the owner under T1 and V3 are the same, but what happens when the owner under T1 and V3 are different? Also, Section 14B is a new arrangement. Under Section 19V7, there is a requirement of a bona fide buyer. So can you give us all the scenarios? The Permanent Secretary said that they will work out a mechanism together with the Hong Kong EAA and the Lawyers Society. With all your requirements and provisions is impossible for a bona fide buyer to not be made aware of the recovery certificate. But because under 19V7, it is said that the charge is not effective when there is a bona fide purchaser. However, the charge will only be discharged when the payment is settled. Can you give us a flow chart so that our legal advisor can also look into whether the problem's been addressed?
Yes, thanks very much for the question. The first one is 14B1. That's about non-compliance with the DO and FSCO. Now, under these circumstances, to avoid a situation where the new buyers concoct some excuses to avoid legal liability and impede the progress of the work, we would require the new purchaser to notify the enforcement authorities of the transfer of interests. And this is what we are seeking to do. At previous Bills Committee meetings, we would mount publicity extensively to make sure that everyone, including the real estate agents, the owners, to understand the extent of their responsibility. And for Section 19, we do have elaborated this. The 17V71, that's in paragraph 12 of the paper. Now, for some other scenarios, if there is a new owner coming in, now that's in paragraph 13 of the paper. If the new owner is a bona fide purchaser, then 19D1 will be activated. And paragraph 14 has covered this particular point. We have elaborated these in the paper. I hope that will be sufficiently clear for members to have a good understanding of the entire procedure. And I hope the members will take note of these. Ms. Carmen Khan. Number 14B is when the directions and the order are still in place, there would be a notification that would be required within 3 months. But once you have carried out the defaulted work, would that be gone? The yes. If there is a transaction before the completion of the defaulted work, then 14B1 will kick in. It all depends on whether the direction is still in force, Ms. Khan. What the defaulted work is going on or is completed, the direction may not have been taken away. Now, the transaction is a process. Can you give us some flow chart to help us to get to grips with this particular scenario? Because there is a liability and there is also a charge registered against the title. I defer to Ms. Zhang for the detailed process. Well, 14B, as indicated in the bill, is about the directions and FSCO are still in force. There's non-compliance of 572 or CAP 572. They may be making preparation for the work, and 14B would be covering this. But for defaulted work, that's before the works are completed, 14B will also apply. Now, for the recovery of the costs of defaulted work, there's part 4, 19 19T, 19V, 19W. Now, all these provisions are in connection with the recovery of the defaulted work costs. So that's in a scenario where the works have been completed, the directions and the FSCO have lapsed. So a 14B in this kind of scenario will not apply. So when it comes to the recovery of the costs, the defaulted works have been completed and 572 have been complied with, and 14B would no longer apply because that's in relation to the non-compliance of CAP 572. We would require the owners to inform the authorities about the existence of a new buyer, but when the defaulted works have completed, 14B will not apply. We're talking about two different scenarios there. I hope that would I made myself sufficiently clear. Well, I understand that members are really concerned about this, and there are different scenarios. Even right now, you may ask the administration to give you different scenarios, but can this be exhaustive? From what I heard from the administration, statistically and also in terms of the cases they handle, I don't think they have encountered too much difficulty. I'm sure the administration has taken note of members' concerns. We'd like to make this perfect, and we are conferring power to the authority, and we have to make sure that there would be the fallback options. But we cannot anticipate what's going to happen going forward because of the sheer number of scenarios that might crop up. And we're just stating this, we're just putting a marker here for the attention of the administration. And there are so many considerations to contend with that we have spent an awful long time on this. Now, Ms. Kong, I'd like to let you have the last word there, and then the legal advisor, we can wrap up on this point. Chairman, thank you. But in terms of laws on property and land, we do have a comprehensive case law regarding the encumbrances. One of the principles is there may be contingent liabilities. These may become part of the encumbrances. When we are studying the titles, we do have the principles to go by, and these have been handled in court before. Under the buildings ordinance, if people are not contributing to the payment of building orders, cases might go to the court. Under the buildings ordinance, Chairman, you've got a point there. It is really clear there are not that many cases where people are defaulting, and this has been serving us pretty well. So I fail to understand why you make it so complicated in Part 4, Division 4. Now in Division 4, it is a departure from Section 33 of the Buildings Ordinance, to making this terribly more complicated. I am concerned that Section 33 of the Buildings Ordinance, there is a recovery mechanism, and here regarding these fire services works, and we are dealing with this in a different way, and this would cause confusion to the transaction of properties, in particular in terms of the encumbrances. We will be pursuing the title registration system. So when you are doing the registration, what criteria do you go by? 19T, 19V, or what? So, Chairman, I don't really want to spend too much time on this. I like to write to the administration with my personal opinions together with all the case law. Yes, title registration, this is not an issue for today. I know that there are so many different considerations there. Perhaps our legal advisor might wish to say something about this. Chairman, thank you. Thanks very much. Members focus their attention on a number of provisions, 19T, 19V. Well, 19V is about the costs shouldered by a bona fide purchaser. The administration has done a lot of explanation. Perhaps I'd like to approach this issue with some practicalities, and also the application of 14B. Now, under 14B or 19T or V, we have to imagine three individuals. They are the owners at different times, and this may involve two different transactions. Now, if you can imagine this kind of scenario, why we have 14B and 19T and 19V. Now, 14B, in terms of application, is applying to the first transaction. Now, the owner has received the safety order, and some work will have to be undertaken, but the work is still in process. And in the process, the property has been transferred to a new buyer. And the next buyer under 14B will have to notify the authorities about the transfer of interests within 3 months. So can the administration confirm that this is how 14B would kick in? That's why they need 14B. And when it comes to 19T, it is about something different. Now, why is it that the administration has a claim? It is because there is a debt that has arisen. Now, why the debt? According to the administration's logic or mechanism, when the default work is completed, like when you're done with your dinner, you settle the bill. That's the process of settling the bill. The work has been completed, and you have to settle the bill. And if you don't settle, there is a debt there. Now, with any occurrence of a debt, it is really a personal claim. It is a claim against the person. So under the government's mechanism, who are they claiming the money from? And that's the owner. It's about the individual being an owner of the property. So when we look at 19T, 19V, that's the assumption, and that's the pursuance of a debt. The 19T, when the default works are completed and there is a debt arising, and we have to ascertain who the owner is at that point in time. So the administration can confirm this. Normally, under the law, we have to search the land registry for the owner. Whoever is there is the owner. For the second owner, when the default work is going on, now when the work is completed, he doesn't pay up, and the recovery notice has been issued but has not been registered. And at that point, the property is transferred to a new owner, and the third owner under the law would become the owner here. And according to the principle of fairness, the recovery certificate has not been registered. Even if the third owner under 19T, now 19T is about the completion of the default works, and and who the owner is. Now, that person will be held responsible, even if this is the owner. If he can prove that he is the bona fide owner, he doesn't have to be held responsible for the debt. That effectively is the administration's position under 19T. That's the whole concept underlying this. Now, there is a debt still outstanding. Then under 19T, the second owner who refuses to pay will be held responsible for that particular debt. That's some sort of a summary to enable members to understand the sequence of events in terms of applicability of the law from 14B transitioning to 19T and V, what's likely to happen in this sequence of events, and how, if I understand correctly, how the government designs the whole process. Thank you.
I see.
Thank you, Ms. Chan. Deputy Secretary. I thank the legal advisor for the explanation. That's the same as our understanding, and that's the legislative intent as well. Ms. Khan asked if the provisions are new and if we have just copied from the Buildings Ordinance. Well, for 19T and V, the provisions exist in the Buildings Ordinance as well. They are set out in 30B bracket 11 and 33 bracket 9 under the Buildings Ordinance. These are the provisions that we made reference to. Thank you. We have spent a long time on this, and the members, I believe, have expressed their concern. The administration may have to consider setting out the mediation recommendations in your guidelines. Regarding administration's response to the issues raised at the meeting on the 15th of October, that also cover the new Section 22A. We raised issues with the wordings. Any questions from members? If not, then we have wrapped up our discussion on CB bracket 21357/2024 bracket 02. Let's proceed to clause by clause scrutiny. We should start from Section 22B in this meeting. That is page C1971 in the blue bill and page 45 of the marked up copy. Ms. Chung. Thank you, Chairman. Please refer to C1971 of the bill and page 45 of the marked up copy. The new Section 22B is to include prosecution deadline. We propose to make reference to the Fire Safety Industrial Building Ordinance to set up or establish a prosecution deadline. The prosecution for an offense under this ordinance may only be started after or before the end of the 12 months beginning on the date on which the offense is discovered. We have made reference to the Fire Safety Commercial Buildings Ordinance as well. We will make relevant amendments to Cap 502. We will elaborate on that later on. Now, clause 24. Please refer to C1972 of the blue bill and page 46 of the marked up copy. We add Division 4 Service of Documents. That's because we want to increase the number of ways EA can serve documents on the relevant persons. Please pause here. Ms. Doreen Kong. I'd like to ask about 23C. It is said that the document may be left with an adult occupier of the building. A lot of flats are rented out. Is the document considered to have been served if the document is served on the renter? Well, we actually haven't reached that part yet. Although we have covered Division 4 services documents, if you have no question regarding the prosecution deadline, maybe the administration can respond to Ms. Kong's question. Thank you. As for the service of documents, we make use of registered mail to serve the instrument, and we will also put up the document at a prominent place in the buildings. The adult occupier could be the renter, and we will we will ask the person renting the flat to inform the owner of the instrument. We make use of registered mail, and we will also put up the instrument at a prominent place in the buildings. Thank you. Now we proceed to 20. My apologies. We have covered Section 23, Service on Non-Body Corporate. Let me talk about now Section 23. Please refer to C1973 of the bill and page 46 of the marked up copy. Section 23, Service on Non-Body Corporate. That is to be replaced by Section 25, and we have added a new Section 23. Under the section, the EA will serve documents onto a person who is not body corporate. Currently, we can only send it by registered post, and under the new provisions, we have included a number of ways for the service of documents. We have made reference to Cap 636 to amend Cap 572 so that instruments can be served on the person through registered mail, fax, email, and so on. To make it more convenient for EA to serve documents, we have also included Section 23A to set a date for the delivery of documents. We'll also make amendments to Cap 502. Ms. Kong also asked if the document will be served on the occupier of the building. As mentioned by the Deputy Secretary, we mostly deliver the documents via registered mail or put it up in a conspicuous place of the building. There are different ways for us to serve a document. We will only serve the document onto the occupier upon request of the owner. That is, upon instruction of the owner. The department will make use of the most appropriate ways to serve the document. In any case, Ms. Doreen Kong. For 23 and 23A, well, I'd like to ask about email address. For Section 23, it is said that the document may be sent by electronic mail to the person's last known electronic mail address, if that address is unknown. I'd like to know what you mean by usual electronic mail address. You said that you have made reference to Cap 636, but that's not how the provisions are written in that ordinance. Under Section 48 and 49, it is only said that the document will be sent to the electronic mail address, but not usual electronic mail address. Why do you add the word usual here, Ms. Chen? Thank you for the question. We have made reference to section cap 636. We have only adopted the concept of that here by including more ways of service. The member asked about the last known electronic mail address and the usual electronic mail address. We have actually made reference to the competition ordinance, section 167. You said that you have made reference to other ordinance. Cap 636 is the Fire Safety Industrial Building Ordinance, which is similar to this bill. They're both about fire safety. I think that the administration should make things consistent. Otherwise, members of the public may be confused. I think, well, because service of document is very important, please make things consistent. Let me ask our colleagues from the DOJ to assist. Mr. Y. Thank you, Chairman. Thank you, Ms. Kong, for the question. Just now, Ms. Kong asked about Section 23, bracket F, electronic mail address. The EA will send the mail to the usual electronic mail address, and if that address is unknown, then the mail will be sent to the person's last known electronic mail address. We have made reference to subsection B. We adopt the same or similar wordings. We will send the post to the person's usual address of residence or business. Only if that address is unknown, we will send the post to the person's last known address of residence or business. We just try to keep things consistent under the same ordinance. So under F, we will send the mail to the usual email address first, and if that address is unknown, we will send the mail to the person's last known email address. I think that's the legislative intent. Ms. Kong. I'd like to ask the administration to read Cap 636. Section 68B. When it comes to registered post, we use usual address because we usually only have one residence, but a lot of people have many email address, so the concept of usual email address is weird. That's a comment. Ms. Kong raised doubt about use of wordings. We will look into whether we should make amendments. But I think that the word or the term usual email address can be understood quite easily. Now, I think that you have stated your comment. The administration will look into it. There are often inconsistency in terms of wordings across ordinances. The administration will consider a number of factors. At the appropriate juncture, maybe you will make amendments to other ordinances. We often talked about the Chinese translation of various ordinances. Sometimes we make amendment to the Chinese translation of bill, and we cannot make the same amendments to the similar wordings in other bill at the same time. Dr. So Chong-ming. I'd like to ask about Section 23, Service on Non-Body Corporate, bracket E. It is said that the document may be sent by facsimile transmission. As we all know, we are no longer using fax that often. Most people are making use of mobile phones. Will the administration include mobile phone messages or text messages here? Now for bracket D, it is said that the document may be posted at a conspicuous place inside the building or part of the building. What is the definition of a conspicuous place? It could be inside the toilet, it could be at the entrance. It's rather vague. Will you define conspicuous place? Thank you.
Well,
conspicuous place, I think there is a common understanding, isn't there? But I defer to the DS. Chairman, thank you. 23A, regarding the service of documents, that's to have a wide variety of different means to make sure that the recipient would be able to receive the documents. Definitely, we will send registered mail, and posting at a conspicuous place will be done. As to the actual situation, our experience shows that we managed to deliver the document smoothly. But the service of documents by various means is intended to achieve the original purpose. You've done this before. As to the future, I think we can adjust as we go along. What the government states here is merely to provide a variety of means to serve the documents. Yes, please. Page 51, 52 in the marked up copy, section 27, part 4. We're at division 5, evidence. That's to enhance the prosecutorial work. We have regard to the mechanism in CAP 636. And under 23C, the certificate of giving or service admissible as evidence. And 23D, the fire safety directions and the compliance order. This is the power to certify documents, and by 23E, these certified true copy can be admissible as evidence. Other than referencing CAP 636, we also had regard to other ordinances. And in CAP 502, there will be corresponding amendments. I'll be briefing members on this. And section 27, clause 27, we add division 6, rules and regulations, C1 line 02 to 1099, page 53 to 58, 23 to 26. That's regarding the technical amendments to schedules 1, 2, and 3. Now, for these three schedules, the fire service and installations, we make it commensurate with the interpretation, and also we add the public parts. We add this to make it commensurate with interpretation of the enacted ordinance. And the last part, division 3, that's in relation to 502. Here, the amendments are pretty similar to 572, C1109 to page 60 of the marked up copy. That's amending in two ways. The existing interpretation will be technically amended, and we add new definitions for the technical amendments. The current 502 regarding compliance orders. We have definition for the compliance orders. The purpose of this amendment is to make it clear that this is amended under the existing ordinance. This is a technical amendment. For the new definition, where members please refer to C1192 and page 60 of the marked up copy. Here we add a new definition to commensurate with the 572. We'll add these public parts, and this is in line with CAP 572, and this is done in accordance with Section 2 of the Building Management Ordinance to achieve a consistency of the law. C1922 and page 66 of the marked up copy in CAP 502, we add 13A, and this is in line with 572 to enable the authorities to include all the information, the serial number, the issue date, and the address of the buildings. We add this to enable the members of the public to know that certain buildings have failed to comply with the regulations, and that's corresponding change to CAP 502. Ms. Doreen Kong, Chairman. Now, for many buildings, in particular large ones, they are composite buildings with residential and commercial elements. Now, for these common parts that are related to the entire housing estate, are you going to be using CAP 572 or the commercial premises ordinance? How do you make the distinction there? The yes, I defer to Mr. Yong. Chairman, thank you. Well, it all depends on the status of the building. If this is a residential building, it would be 572, commercial premises 502, and we also have the CAP 572. It all depends on the nature of the building when deciding which ordinance would apply. Ms. Zhang, C1944 and marked up copy, page 67. Section 33, 34 are technical amendments. This is the same as CAP 572. Section 1920 of CAP 502, the government will be revised to SAR government, and this is in line with CAP 1. C1994, 1996, and marked up copy 68. 502 doesn't specify the limit of prosecution. Here we will make this in line with CAP 572, and we have regard to CAP 636 to impose a prosecution deadline within 12 months of the offense. There will be a prosecution deadline. And now C1996 to 2004 and marked up copy page 69 to 72, clause 32, 20, 28, 22B, and this is in line with 20, 23A, 23B, and this is in line with CAP 572. We do this on the basis of CAP 636 to allow more means to serve the documents for the owners or occupiers to receive the documents. We also have regard to CAP 636 and put in place 22B, and regarding the date of giving or service of documents. Now, see 2004 and 2006 and marked up copy, page 72 to 74, section 37 under cap 502, 22C, 22D, 22E, and they are related to the evidence, and this is in line with caps 572 that we discussed. This is to enhance the efficiency of the prosecutorial work, and through 22C, B, C, and D, the certificates of giving or service admissible as evidence. And this is the corresponding change to 502. C2008 to C2112 and marked up copy 75 to 83. Section 35 to 38 is in relation to Schedule 235. In the schedule, there is mention of fire equipment installation, and we make this in line with 502 and also cap 502. In the interpretation, we add the public parts to amend this to public parts. Chairman, I have already covered the entire bill. Thank you very much. Thank you, Mr. Cheung. All right, we're done with the scrutiny of the clause-by-clause bit of the bill. And I noticed that members have raised certain points to be followed up. Like Ms. Doreen Kong, she will be writing a submission regarding her views, and I hope that the administration would make a response as a matter of urgency upon receipt of the submission, and then we decide whether we will follow up on this. Also, Mr. Andrew Lam will be writing to the DOJ direct, and he would like to find out more about the time frame regarding the recovery of debt. I leave it to you, Mr. Lam, in this regard. Ms. Carmen Khan made the point that there should be a more comprehensible chart to enable members to get to grips with the fine details and procedures of the process. Yes, care to take this up? Chairman, we're only too delighted to make this available to members, and thank you very much for members' comments, which are so invaluable. Grateful thanks there. Now, regarding the flow chart, we are prepared to make available the information. Well, basically, we are done with the scrutiny of the Chinese version. I like to ask the legal advisor as to whether the English version is also in order. Chairman, thank you. But the Legal Services Division has not really picked up any particular issues in the English version. Members recall that after the third meeting on the 24th of September, we did invite members to submit CSAs. On the 7th of October at 5 by the close of play, the Secretary has not received any proposed amendments for discussion by the committee. The administration has CSAs to move, as I said, CB 21357/2405 and CB 21193/2024 705. DS. Anything you'd like to highlight there? And I wonder whether members have any comments to make regarding these amendments. There's 22A, if I remember correctly. Members seem to have accepted this from what I gather a moment ago.
We have briefed members of the proposed amendment during the clause-by-clause scrutiny. We note that members have no comment. If members have no comment regarding the proposed amendments, then legal advisor, any comment? No comment. As I've mentioned, we have completed this the clause-by-clause examination. There are a few things that the administration should follow up on. Regarding the resumption of second reading debate, we have a timetable. We will see when the administration will make available their response before we decide on the date. Well, I will perhaps send the response submitted by the administration to the members. If the members is of the view that we have to organize another meeting to discuss it, then I will hold another meeting. If the members think that we don't need another meetings, then, well, perhaps the clerk can brief us on the timetable if another meeting is not needed. Thank you, Chairman. Well, depending on the time when the administration submit their response, we can start resumption of second reading debate in the council meeting on the 4th of December. If we resume the second reading debate on the 4th of December, then the Bills Committee will have to make a report to the House Committee on the 22nd of November. In other words, the administration should have submitted their response before that date, and the members would have to have no comment. If more time is needed, then the second reading debate will be resumed on the 11th of December, and the report has to be made on the 29th of November to the House Committee. Thank you. We have to look at, first of all, when the administration will submit their response to the members' questions and comments. And second, we also have to look at whether members think that we should hold another meeting to discuss the administration's response. And third, we have to look at the preference of the administration. As the chairman of the Bills Committee, I hope that we can resume second reading debate by the 11th of December, the latest. Please note the timetable. The two dates that I proposed are the earliest dates. Please consider. The speaker's mic is off. Ms. Khan, please write to the administration as soon as possible so that we can resume second reading debate on the 4th of December, Wednesday. Any other business? There being no other business, the meeting is adjourned. Thank you. Thank you.